connection to her. And I would like to introduce everybody to Katherine Chu. She is a long-time friend of Family Focus Resource Center and has been doing these presentations in our support groups and in our communities for a long time. So we're really, really appreciative of her time and all of the great information that has benefited our families over the years and all of you today. So I will put the PowerPoint on the screen and we'll get started.
Can I just say something?
Sure.
I just wanted Christine to introduce herself as, and then I'll introduce myself so you'll know how we tie into Family Focus Resource Center. So Chris.
Thanks. I'm Chris Gutierrez, and I'm a parent of a child with autism who's 18, and I'm going through conservatorship myself right now. And also, I work in the Antelope Valley office of Family Focus.
And I'm Teresa Query with the Family Focus Resource Center office in the San Fernando Valley at the Chatsworth office. We also have an office at our CSUN campus for non-regional center consumers, as well as we have a Santa Clarita office. And we're here to support you with resources and such webinars and Zoom meetings such as this. So with that, Katherine, it's all yours.
Okay.
All right.
Okay. Hi, everyone. It's good to see you. Thank you so much for signing in. The purpose today is to generally go over some of the basic laws about conservatorships and also alternatives. Conservatorship is not always the thing you want to do. It depends on your situation. So I'm hoping to get started and maybe kind of clear some of the mystery you might have with regard to that. So thank you for joining us. So we can start the PowerPoint, I guess. Go ahead. Oh, I don't hear you. Okay, there you go.
I'll pull it up. Give me 1 minute.
Okay, and while she's doing that, I do, it's my understanding from Teresa that we have people from Riverside County and other counties besides LA County. So some of the issues differ from county to county as far as paperwork to file, but generally in today's presentation, the basic law is going to apply to all counties. So we'll get through that. Okay, we're going to get to that front slide here.
Okay, can you see the screen?
You can see the screen. We're on the last slide.
Oh,
So,
hold on.
Sort of like having dessert first.
Okay, I see the first screen.
okay, let me just, yeah, I can't move it up.
Okay, let me try
Okay.
again. Hold on just a second. All right, hold on.
On enable editing, and yeah, there you go.
Okay, there we go. All right, so welcome to our class, Finding the Right Path for Your Developmentally Disabled Person. And there we go off the side there. There we go. Okay, and as I said, we're going to talk about alternatives to conservatorship because conservatorships may not work for you in your particular situation. Okay, so let's go to the first slide. Christine, you can switch the next slide. Okay. The thing about a conservatorship, it is for an adult. Okay. So when you think about a conservatorship, it can be a young person, maybe like your son or daughter who's now just turning 18, or oftentimes it might be an older person who's maybe has dementia. But the thing to remember is it has to do with any adult. So if any of us were maybe suffered from some traumatic brain injury or in an accident, somebody might step in to try to file for conservatorship. It is a way the law has provided to help somebody who's an adult who maybe cannot take care of their own personal affairs or their financial affairs. All right, so just remember that. You have to be 18 and above for conservatorship to apply. Okay, next slide. What does it mean when you hit 18? Okay, in the eyes of the law, when you hit that magic age of 18, the law presumes you can do all things an adult can do. You can decide who you're going to marry. You can decide whether to go to the doctor or not, whether to buy a house, where to go to school, whether to go to the doctor, how to manage your money, how to vote. All these things automatically come forward if you're at age 18 and above. But all of us know, based on your personal experience, that that's not how the real world works. You know, oftentimes you may have somebody who's developmentally disabled, or you may have somebody who has some sort of physical or mental disability, and they cannot operate these normal adult activities. And so that's why the law has carved out the area of conservatorships. And the thing to remember is in conservatorships, the focus is going to be on the disabled person. What can we do to help this person live in the most open environment, in the least restrictive environment, and to be able to help in certain ways that they do need help, but not to take their powers away unless they actually need help. A conservatorship is basically taking somebody's basic civil and legal rights away. So the court wants to be very, very careful before they go down that path of a conservatorship. So before you even go that route, the court is going to ask, is there another way to do this? Is there another way to help the person who's disabled? Next slide. So the first question you want to ask yourself, and the court's going to ask, is do I really need a conservatorship? Or is there another way we can do this thing to help this person who's disabled? So there are certain ways you can help a disabled person without going through a conservatorship. So we're going to talk about those first, alternatives to conservatorship. Next slide. The first one is maybe this disabled person can accept formal and informal help. Maybe they realize, hey, I'm having some difficulty maybe managing my finances or taking care of myself. And if that's the case, you might just try informal and formal help to help this person who's disabled in some way. For instance, when my father started to get dementia, he started realizing, I need help with some, managing my money, and I need help with my medication. So my family just got together, my brother and sister and I, and we gave him informal help. I took care of with my mother and helped him with his physical needs, and my brother helped with his finances. And we didn't need a conservatorship, and my father's needs were taken care of. So that's one way to avoid a conservatorship. You don't have to go into court, and you basically just help. Next slide. Another way to avoid a conservatorship is called a durable power of attorney. It is a legal document, basically. All it does, it gets witnessed, it gets notarized, and it is a document that allows the person who needs help to just say, you know what, I know I realize I have some help, I need some help, so I'm going to designate this particular person who I trust to make decisions for me. It's called durable because it has some language in there that says, I've picked my son to take care of my finances, but just in case, if I become incapacitated, I want this to still apply. So that's kind of the durable language in the power of attorney. It's not monitored by the court. It's just a legal document that gets witnessed and notarized. So it's one way to avoid the whole court process of conservatorship. A conservatorship is a very involved process. It takes several months. It involves the court monitoring the situation, and once a conservatorship is in place, the court is going to continue to monitor it. So you may not want a conservatorship if indeed a durable power of attorney is available. The one thing to know, though, is a durable power of attorney is only effective if the person is of sound mind, okay? They have to understand it's my legal right to make my own healthcare decisions, but I'm feeling like I might need some help, so I want to designate my daughter as my agent. And I understand I'm giving my own power to make my own decisions to this other person to help me, all right? So if you're in a situation where maybe you have somebody who's autistic or they have a brain injury and they may not be offering at the level of an 18-year-old as far as the mental capacity, that might not work. So you've got to be able to know whether the person really has the capacity to understand the legal consequences of signing a power of attorney. If they don't, then you may need a conservatorship. Next slide. Another way to make decisions about health care is called an advanced healthcare directive. It's another way to avoid the conservatorship. And like the durable power of attorney, the person has to understand that this is a legal document, they're signing it, and they are picking a person to make healthcare decisions for them. So here in this slide, it basically lays out what an advanced healthcare directive is, but it basically has an adult who wants to appoint an agent to make his or her healthcare decisions for them. And they can give the authority to also make end-of-life decisions if that is the case. And they can also mention in the advanced healthcare directive that I would nominate this particular person to be my conservator if indeed I become incapacitated. And it gives the agent access to medical records. They can carry out specific burial arrangements. It basically helps that person appoint somebody to make decisions about their health care and physical needs. Next slide. Another way to avoid a conservatorship if you have to manage assets is create a trust. It is a legal document. It is a document that basically says an adult can be appointed, can have a trust drawn up to have somebody else manage their assets. You all may have heard of a special needs trust. Maybe some of you have one laid up, but basically that is a special type of trust that allows a disabled person to not lose their government benefits or public benefits such as SSI and Medi-Cal. And the money that goes into the trust is used to supplement their government benefits. So that's an important thing to think about if indeed you have somebody who's developmentally disabled who may have assets coming in, but they're also on SSI and Medi-Cal. You may want to think about investigating the option of doing a special needs trust. So in the event you pass away, they still are able to use, not even if you pass away, it still can be in effect while you're still alive, but that the funds in the special needs trust can be used to supplement SSI or Medi-Cal, and that way they don't disqualify themselves from being entitled to those benefits. Next slide. Another way to avoid conservatorship is just opening up a joint bank account. My mother had a stroke. She was unable to sign checks. So she and I went into the bank. She still had mental capacity to understand what was happening. We went into the bank. We opened up a joint account. She gave me access to her funds, and I was able to pay her bills for her. So this is another way to avoid a conservatorship if you just need to manage some finances. So that's one thing to think about if that's all you need to do as far as helping somebody who's disabled in some way. Also, this is something to think about maybe if you're in a situation where the disabled individual has a big settlement coming in, maybe from a personal injury action or that kind of thing. Oftentimes, a court will allow you to set up a blocked account where the money can be put into that account. You do have to have court approval to withdraw it, but it's used for the benefit of the disabled person. Another way to avoid a conservatorship. Next slide. If you need authority just to maybe have speak for somebody who's disabled as far as their education or their records, you can have an education authorization. That's one way to avoid a conservatorship as well. You basically have your disabled person consent to give you the authority to have access to educational records. And it's only for that sole purpose. If that's all you need is to be able to have access to some of the student records and that kind of thing, you may not need a conservatorship, and an educational authorization may do the trick. Next slide. Another alternative is have a medical authorization signed. And again, this is a very limited purpose, but it will allow a person you designate to have access to your medical records and maybe help make medical decisions in that regard. And you don't need a full-blown conservatorship. So this is another alternative that's available that might just be what you need. But again, all these alternatives depends on whether the person is of sound mind to be able to understand this is my right to make my own healthcare decisions, to have my own medical records confidential, but I am turning over that right to this designated person because I trust them and I want them to help me. Another alternative to conservatorship. Next slide. Now this is an important one. If you have somebody who is on SSI, that's supplemental security income, not Social Security, it's very different. you can just become the rep payee. I'm sure a lot of you already are the rep payee for maybe your son or daughter, but this is a way to avoid a conservatorship of the estate. Basically, the SSI money belongs to the disabled person. It's their funds, but if you are designated as a represented payee, you can manage the money for them, you can withdraw it, you can spend it for them, and that's another way to avoid conservatorship of the estate. A conservatorship of the estate can be a little bit more involved, so if that's all the funds a person has coming in, you may just want to become the rep payee rather than file for a conservatorship over the estate. We're going to get into what involves a conservatorship of the estate, but it's far easier if that's the only thing you need to do is just to manage SSI benefits. Next slide. Another way to avoid a conservatorship is just to appoint an authorized representative. Maybe you have an administrative hearing with regard to IHSS or Medi-Cal. Well, the person who's disabled can just designate an authorized representative to speak for them and represent them at a hearing. Another way to avoid a conservatorship, you've just have this narrow responsibility, but it does solve the problem of helping this person who needs some help in some way, maybe at an administrative hearing or to speak for them with some governmental agency. Next slide. Christine, next slide. There we go. Okay, so those are all ways to avoid a conservatorship. But let's say none of that works. You have somebody in your life who's disabled and you know they're not going to understand the legal consequences of turning over a certain legal right to you. If that's the case, you very well may be in the position where you need a conservatorship. And again, remember, it's for somebody who's 18 and above. So the law realizes that when you become a conservator, you are going to become a caregiver. And caregiving is a series of small acts of care that really is going to alter the course of somebody's life. And so they're going to be very careful on whether a conservatorship really is needed. If you are petitioning, whether you're appropriate. If somebody objects, if they're appropriate to object and maybe be a conservator, they're going to be very, very careful because it is basically taking somebody's basic civil and legal rights away and giving them maybe to you or somebody else to manage. So it's a very involved process, and they're going to be very careful before they appoint a conservator. Also, in California, once you become a conservator, the court presumes that you're going to be appointed for an indefinite period of time. And so once you're appointed, at least in Los Angeles County, they will assign a court investigator to come out and check on things after the year you've been appointed, and every 2 years after that. So it may vary from county to county, but do understand, in the case of a probate conservatorship, which we're talking about today under the probate code, the court is always going to continue to monitor the conservatorship, saying, in other words, they have jurisdiction over the case. Okay, next step. Next slide. All right, so let's get into the terms. In California, a conservatorship is basically a court case. It's when you're going to go in front of the judge and you're going to say, I want to be the responsible person to take care of this disabled person. You are going to be called the conservator. The person you're trying to help, meaning the person who's disabled, is called the conservatee. So when you file for your petition for conservatorship, don't mix those up. Those are very important to understand. You are the conservator, the person who's stepping in to try to help somebody, and the person you're trying to help is called the conservatee. You can try to ask the court to help this person manage either their finances or their physical needs, or maybe both. So we're going to take them step by step. Next slide. There's two types of major ways to look at a conservatorship. And really the focus is what this person you're trying to help needs. Under the law, you can be a conservator of the person, you can be a conservator of the estate, or you can ask the court, please appoint me as both. And it really depends on what the person needs as to what kind of conservator you want the court to appoint you as. So let's go to the next slide, and this will describe what you are responsible for if you were the conservator of the person. The duties of a conservator of the person are these: to provide for the care and protection of that person, decide where they're going to live, and remember that once you're appointed, the court now has jurisdiction and is going to monitor over it. So if you want to move the conservatee, you're going to have to notify the court that that is your intent and get permission to do that. You'll be responsible for providing for health care, meals, clothing, transportation, all those things that a person needs to physically thrive, and maybe they need help with. You will be able to possibly, if the court gives you the authority, to make decisions about medical care and treatment and medication and decide whether it's appropriate or not. And if you're going to change the residence, you're going to have to report to the court regularly on what you're doing as far as the conservatee's residence. And in a probate case, in particular dementia cases, you can also ask for special authority to be able to have medical professionals administer medications to treat dementia, and possibly place the person in a secured facility because they realize that people with dementia may tend to wander, and for their own safety, they may need help to be in a secured facility. But that's only in a case of dementia. Otherwise, you have to ask for those special authority for medications for dementia and placement. Okay, next slide. The other one that you might want to ask to be appointed as is conservator of the estate. And this has to do with trying to help somebody who needs help with their finances or their money or their property. So we'll go to the next slide, Christine. And this will list what your duties are as a conservator of the estate. It's a little bit more complicated as far as being a rep payee for SSI benefits. But these are what you would be responsible for if you were appointed. You would be responsible for managing the finances, locating and taking control of any assets, preparing a budget, collecting income, paying bills and taxes, responsibly investing with regard to the disabled person's assets, protecting their assets. And then you're going to have to report to the court with something called an inventory and appraisal. It's a list of everything they own, and it gets appraised and what it's worth. You turn that into the court. And then later on, you're going to have to do an accounting, meaning you're going to have to tell the court, this is what I'm doing with the disabled person's money. This is what I've spent it on. And the court is going to monitor to make sure that you're not abusing your authority as conservator of the estate. So again, you can ask to be appointed as conservator of the person, conservator of the estate, or both. Okay, next slide. Now, the thing about if you're going to be asked to be a conservator of the estate, you need to know how much the estate is worth. And in other words, what the assets are worth as far as the disabled person. And if indeed they have assets worth over $15,000 in assets, you may be required to post a bond by the court. A bond is like an insurance policy. It's basically a way to protect the disabled person because they have given the authority to manage their money in their estate to maybe you or somebody else. And this is a way that the law has built in to keep people honest, basically. This is to prevent the unfortunate experience if a conservator gets appointed and they steal the money or they misappropriate the money. So they're going to make you post a bond. In other words, they want you to have some skin in the game if they're going to give you that authority to manage the estate. All right. So do understand that if you're going to file for conservator of the estate, you're going to have to figure out what the general value of the assets are of this person's estate, and then you'll determine whether the court may very well make you post a bond. Next slide. Now, when is a bond waived? Okay, that means when is a bond excused? Well, there's a code section that says if the asset is less than $15,000, then they very may say this is a small estate, and so we're not going to make you post a bond. These are the qualifications to be a small estate. The person has to have less than $15,000 in assets, but we don't include the house they live in. They have to have a monthly income of less than $2,000 a month, but that doesn't include public benefits like SSI or Medi-Cal, okay? And if anything that's retained is going to be used for the care of the disabled person, the court may very well say, you know what, this qualifies as a small estate, and so we're not going to make you post a bond. So let me give you an example. Let's say we've got grandma. Grandma has dementia. She lives in a $3 million mansion in Beverly Hills. Okay. And because she has dementia, she doesn't understand what's going on with her finances. So she's writing checks and giving money away to the point she only has $10,000 in her bank account. Okay. So step one, is it less than $15,000 in assets in her bank account? Yeah, that's all she's got. But she lives in a $3 million mansion. Do we count that? No. She lives in the mansion. It's her house. It's a big house, but it's a mansion. And, you know, we don't count the value of the house because it happens to be her residence. Now, if you were to move grandma out, put her in a nursing home, and try to rent out the mansion for movies and that kind of thing, it becomes an asset, okay? So that's something to remember, that we don't count the residence of the disabled person as long as they're living there in calculating where their small estate applies. Let's say grandma has a pension of $1,500 coming in every month. She's also blind, so she gets SSI of $900 a month. Okay, we don't count the $900 because that's a public benefit. We only count the pension of $1,500. So you're okay with step two. And step three, you say, hey, I'm just going to keep everything in grandma's account and just take money out, you know, if I need for her medication or her caregiver, that kind of thing. If that's the case, it may very well qualify as a small estate, and the court may agree to waive the bond. Okay. So being a conservative estate is a lot more involved. And so I would suggest to you that if you have a son or daughter that all their income is just SSI, that the route the court would want you to take is to become the represented payee rather than try to file for over the estate. It's just not going to be necessary. Okay, next slide. Now, once you decide what type of conservator you need to be, either conservator of the person or conservator of the estate, then we have to decide what kind of petition you need to file. There's two types, pretty easy, okay? There's a general conservatorship and another one called unlimited. Just understand they're both just as good. People get a little bit freaked out about the name limited. But I think the best way to think about it is this. A conservatorship, if you remember in the beginning, is taking somebody's basic civil and legal rights away. And so they are going to be careful what they do as far as taking rights away from somebody. And a limited conservatorship is just as good as a general, but it has to do with somebody who's developmentally disabled. And we're going to get into more details about that in the next slide. But a general conservatorship is the other type. And that's basically applies to you or me or anybody else who basically, they weren't born with a disability, but suddenly something has happened in their adult life and they need help. Maybe they have dementia, maybe they have a heart attack or a brain injury and they can't function. So if that's the case, somebody would come in and file a general conservatorship, all right? A general conservatorship really for any adult who just needs a higher level of care. They need help with their physical needs or maybe their estate. And it's oftentimes an elderly person, maybe they've got dementia and they're doing some self-neglect and not taking care of themselves. But again, it can be you or me. If we get in an accident, suddenly we can't manage our affairs, somebody's going to come in and file for a general conservatorship. It's general because it's going to vary from person to person on what our needs are going to be depending on our disability. Okay, next slide. The other one I was talking about, which a lot of you are interested in, I'm sure, is called the limited conservatorship. And again, don't freak out about the name. I like to explain it this way. Since a conservatorship has taken somebody's basic civil and legal rights away, maybe your son or daughter, then they want to limit how many powers they take away from your son or daughter because the focus is to have your son or daughter live in the least restrictive environment and to have maximum self-reliance and be independent. So it's specifically designed for developmentally disabled person. They may have a severe or chronic disability due to some mental or physical impairment, and it manifested before the age of 18. Okay, it could last indefinitely, filing for what's called a limited conservatorship. The focus, again, is to have this person develop as much as they can and maybe take some powers away from them and give maybe to you if you're the conservator to help them get along in life and try to make them as independent as possible. So you would end up filing a limited conservatorship if you have a developmentally disabled person. Next slide. The thing about a limited conservatorship is the probate code specifically has 7 areas of life where they think somebody who's developmentally disabled who reaches adulthood may need help with. And this slide shows the 7 powers that you might be able to ask the court to give you if indeed you want to be a limited conservator. All right. The first is to fix the residence or a specific dwelling, meaning deciding where your person's going to live. To have access to their confidential records and papers, such as regional center reports or school records. To consent or withhold consent to marriage or entering a domestic partnership. This is one that's a little bit tricky. The courts and sometimes the regional centers are not really very keen on doing that. It's a pretty basic civil rights, but it just kind of depends on the person's needs. Another is to control the right to enter into a contract, to give or withhold consent to medical treatment. Another touchy one is to get the authority to manage their sexual and social contacts, and also to make decisions about their education. So when you petition to be a limited conservator, you have the ability to be able to ask for 7 powers, which are listed here, but you don't have to, okay? You can say, you know what, my son or daughter is high functioning enough. I think they should keep the right to decide who they're going to marry, or their own decision making should stay with them as far as their sexual and social contacts. If that's the case, you don't ask for those powers. But do understand, in your petition, if you don't petition to ask for those powers, it's going to be presumed that it's going to stay with the disabled son or daughter, all right? Because it is their right as an adult. And unless you ask the court to give you that authority, it's going to stay with them. Okay, next slide. Now, this is something specific to LA County. It may differ from your county if you're not in Los Angeles County. But in Los Angeles County, the regional center must also weigh in if you're filing for limited conservatorship. For those of you who don't know what a regional center is, it is basically a nonprofit corporation that with the California Department of Developmental Services, and they provide all sorts of resources and services for people who are developmentally disabled. It doesn't matter how old you are. If you were developmentally disabled, you have the right to be a consumer of their services. They basically provide things like counseling or life skills assessments, diagnosis, training, education, and you must be developmentally disabled to get their services, meaning that you have to have a substantial disability that manifests before the age of 18. And basically, the court is going to require that a regional center gets a copy of your limited conservatorship petition, so they know you're moving forward with that process, and then they're going to be asked to provide a regional center report, so the court can consider that before they appoint you or somebody else as a limited conservator. Next slide. So when does a conservatorship end? Okay. In a probate conservatorship, you're presumed to be indefinitely appointed, as I said in the beginning, but there are ways for it to end. Take, for instance, you're appointed as conservator of the estate, okay? Say the money's been spent. There's no more money to manage, no more assets. If that's the case, they'll likely end the conservatorship over the estate. Same with a conservatorship of the person. Maybe you applied to be a conservator of the person, they appointed you, the person was in a coma, and suddenly they wake up and they're fine and they're able to make their own decisions. If that's the case, the court will be inclined to end the conservatorship as well. As I said in the beginning, the court is not really interested in doing conservatorship unless it's absolutely necessary. So there are ways for it to end if the person can manage his own affairs, either financially or physically. Another way a conservatorship can end is if the conservatee dies. Just remember that a conservatorship is to help somebody while they're alive. If they pass away, then there's no conservatorship by operation of law. Another way for it to end is if the court removes the conservator, okay? You remember I said the court investigator is going to check in after a year you get appointed and then maybe every 2 years? Well, this is where the court is going to monitor things. They're going to say, we've given you this big important duty to manage this person's either physical needs or their estate or both, and we want to make sure you're doing your job and meeting your responsibility as a conservator. So if indeed they find out that you've been neglecting your duties or that you've been abusing the person or that kind of thing, the court very well may set a hearing to remove you as a conservator. Somebody in the family or some other person might say, you know, I don't like the way they're treating the conservatee, so I'm going to file a petition to ask the court to remove them. There's all sorts of ways in litigation that a conservator can be removed, but that is one way for conservatorship to end. Another way is if the conservator dies. Okay, now this is an important thing because in a conservatorship, you can have more than one conservator help you. Oftentimes it's parents, sometimes it's son or daughter and parents. By law, you can actually have as many conservators as you want, but I would indicate to you that you want to do what's practical, because when you have a co-conservator, the law provides that every co-conservator has an equal say in the care of the conservatee. They are appointed with basically equal authority, and if indeed one passes away, you need to understand that your official documents are not accurate, so somebody's going to have to go in and refile. But if a conservator dies, especially in a limited conservatorship, there has to be some paperwork that has to be redone to amend your letters of conservatorship, which is the official document that you need to show the bank or the hospital you've been appointed, and remove the name of the person who's passed away. But a conservator, if a conservator dies, you need to understand that by law, there are some things that need to be done to make sure the conservatorship still is in place. And finally, you can resign. If it turns out it's too much for you, maybe you move away, this sometimes happens, other family members step in, you would have to file a petition to resign. And the court at that point would say, well, we've already established this person needs help, they need a conservatorship, so if you're leaving, who is going to step in? If it turns out there's nobody, then oftentimes the public guardian, which is with the Department of Mental Health, will step in and file to be or be appointed as a conservator if nobody else will do it. But there are ways for the conservatorship to end, but just understand that if you're appointed, it's presumed that you're in there for an indefinite period of time. Next slide. Now, once we've decided how we want to be a conservative person, conservative state, whether we're going to file a general petition or a limited petition, I want to explain to you how the court process is going to work, because it is long. It's several months long, but you know, with the right help, you can get through it. So, you know, don't be discouraged. So let me explain what's going to happen in the court process. Next slide. All right. I like to use this slide just so you all understand it can be involved. This is a list of all the documents that need to be filed if you're going to seek to be appointed as a conservator. So don't freak out. There are ways to get it done. You can, of course, consult an attorney, and you know, I'll talk a little bit about the Bethesda Clinic that does things for free, helps people for free. But understand, this is why the court takes it so seriously. So they have several documents they want filed to find out about you, find out about the person who's the subject of the conservatorship, to find out who's in their life, who's going to act in their best interest. And that's the thing to know. A conservatorship is going to be focused on what is in the best interest of the conservatee, meaning the disabled person. I've highlighted letters of conservatorship because, as I mentioned before, that is the official document that the whole goal is at this conservatorship is get your letters of conservatorship. It's basically a pre-printed form by the Judicial Council, but it's treated like a birth certificate. It is the official document that shows you have been appointed to take care of this person in certain ways, either to help their physical needs or their finances. So it's a really important document. And all of these documents listed is what we have to file to get you to the point of getting your certified letters of conservatorship. Next slide. All right, one of the first steps in filing for conservatorship is to provide the court with what's called a capacity declaration. It is a pre-printed form that you would take to the doctor of your son or daughter, whoever you're filing for, and have the doctor fill it out, because this is what the court uses for a medical basis to say this person truly has some mental or physical disability that prevents them from conducting their adult activities. Okay, so the capacity declaration is required by the court. It's listed in probate court as a requirement. And that way the court is going to have some medical basis to say, yeah, this person has some disability and we need to step in to help them in some way. It's you know, a short document. It's a 3-pager if you're filing for a limited conservatorship, but if the person has dementia, there's another page, a 4th page. And that's where the doctor checks off different boxes to say, you know, this person has deficits in maybe short-term memory or reasoning or logical thinking, that kind of thing. And that's going to be required. Next step. Once you file all those documents we listed in that previous slide, as well as the capacity declaration, you're also going to have to serve, meaning send a copy of your petition to all the relatives of the first and second degree of the disabled person. Okay, what does that mean? It's listed here. The disabled person's parents, grandparents, spouse, brothers and sisters, children, and grandchildren. As far as the age of the person who gets a copy of the petition, the relative, it's age 12 and above. If it turns out that maybe the parents or the grandparents have passed away, you'll have to indicate in your petition, why they're not getting a copy of it. And, you'll just indicate that they're disabled, or they're deceased in some way. But if there's some estrangement and you can't find that family member, the court is going to expect in your petition to give an explanation. Well, what efforts did you make to find this particular person? And that's because they take it very seriously. They want these relatives especially to have notice that you are trying to file for conservatorship. Okay, so just be aware that that's going to happen. Once you file, you must serve the relatives of the first and second degree of maybe your son or daughter, whoever you're filing for. Next slide. When you get prepared for the hearing, you're also going to have to serve a copy of your petition to the regional center. And again, this is in Los Angeles County a requirement. The service coordinator is going to get a copy of your petition, and then once they're alerted that a conservatorship petition has been filed, they are required to do a report to the court, and they basically weigh in what they think about the need for conservatorship. They may report about issues that arose while they were a consumer of the regional center. So it's very important to realize that when you file a limited conservatorship, the regional center is going to weigh in as far as whether a conservatorship is necessary, whether they think you're appropriate or somebody else might be. Next slide. The other thing that happens in the process is that they're always going to assign an attorney to represent the conservatee. This attorney is called the court-appointed counsel. They used to be called the PVP, Probate Volunteer Panel, but now they're calling it the CAC. You'll hear them say. And basically, you need to understand the role of this attorney. This attorney is assigned to represent the disabled person, not you, okay? So they are supposed to be the advocate of the disabled person in the whole process. They are the voice of the conservatee to the court. They will probably come out and meet with the conservatee, talk to them, explain the process, explain who is trying to be the conservator, and what they ask them, what they think about it. And when they get to court, they're going to have to tell the court what you as the disabled person think about the whole process. The court-appointed counsel will probably also talk to you as the petitioner, maybe other relatives. Their duty is to find out who is in the life of this disabled person and to find out who's taking care of them, if they need the care, if a conservatorship is appropriate. They are charged with the duty of turning in a report to the court as well. So in a limited conservatorship, which a lot of you might be filing for, you're going to have the capacity declaration that gets filed with your petition documents. You're going to have the court-appointed counsel's report that's going to get filed before the hearing, so the court can hear what the court-appointed counsel recommends and has discovered in their investigation, and also the regional center. Another thing the court is going to want at the time of the hearing is going to be the next slide. So next slide, please. And that's a probate investigator. The probate investigator gets automatically assigned to the case by the court. They don't represent anybody. They basically are charged with finding out more information about who is petitioning to be a conservator. So checking out the background to find out if the person has filed for bankruptcy, if they had any restraining orders against them, if they've had any crimes or a criminal record, that kind of thing. They also are charged with going out to meet with the proposed conservatee, the disabled person, and they have to explain the process again to them and find out what they think about the process, and also put it in a report to the court. So you're going to be visited by a lot of people, basically, if you petition to be a conservator, because you're going to have the court-appointed counsel probably show up to talk to you, and in particular, if your son or daughter, whoever you're filing for, lives with you, they may very well meet with you at the same time they meet with their client, who is the conservatee, and also the probate investigator. One thing to know in Los Angeles County is as part of the process, sometimes the probate investigator may make an unannounced visit, okay? Usually they don't on the first visit, but sometimes, depending on the case, they very well may just show up. Why? Because their duty is to find out the real thing, what's going on in the life of the conservatee, and maybe for whatever reason they feel like, hey, maybe if I just show up, I might gather some more information and see how the situation is as far as who's caring for the disabled person. So just be aware of that. Doesn't happen in all cases, but indeed it is part of their duty to give as much information they can to the court so the court can make an educated decision about whether conservatorship is necessary and maybe whether you're appropriate or not. Next step. Slide. Okay. Okay, let's say you get everything filed, you've met with the court-appointed counsel, the investigator has come out, the regional center, if you're filing for a limited conservatorship, has come out, and everybody's done their report. You'll get to the hearing, and basically, you're responsible as a petitioner to attend the hearing. The PVP, actually, is a court-appointed counsel, will attend the hearing as well on behalf of the conservatee. It's very important that your son or daughter, whoever's a disabled person, if they can, be at the hearing. The court and the law requires that they appear unless their attorney has made a determination that there's an exception to the case. But understand that the court prefers to see who is the subject of the conservatorship. The judge may very well ask them questions just to find out what they think about it, to maybe understand their disability and that kind of thing. So I know some of you are saying, oh no, my son or daughter, they don't like being around a lot of people, you know, their disability causes them to act out. Please understand the court really understands that. This is a conservatorship court, so they know they're dealing with possibly somebody who's disabled. Maybe they don't like being in the courthouse. Maybe it's extremely upsetting to them. If that's the case, you know, you have the opportunity to talk to your son or daughter, the CACs, before the hearing and talk that over with them. And if indeed they have to be at the hearing because there's no medical inability, then you can check in and tell the court, hey, my son or daughter is upset. You know, they don't like it here. There's too many people. It's too much stimulation. If that's the case, the court and the personnel completely understand that, and they'll try to accommodate you the best they can, maybe have you sit in the hallway until your case is called. But do understand that is a requirement that the conservatee be at the hearing, because basically it's taken their civil and legal rights away, and the court would prefer to have them there. But again, you have the opportunity to talk about this with the court-appointed counsel and make a decision after, well, they will make a decision because it's their client, but you can at least voice your concerns about the conservatee coming to the hearing. The court will then make a decision at the hearing, hopefully. Sometimes things might be missing. They may have to continue the hearing, be aware of that. But basically, at the hearing, the court will, after considering all the documents before them, will make a decision whether somebody should be appointed as a conservator. There are some documents that need to be filled out afterwards, including a judge's order and letters of conservatorship, duties to conservatorship, and some other documents that will inform the court about what kind of care the person needs. But that all gets done after you get appointed. Next step. And as I mentioned before, the court investigator is always going to come out after you've been appointed. And this is to always check, do we still need a conservatorship? Have things changed? Is the conservator doing their duty as a conservator? Is the conservatee being taken care of? And basically, they're going to have to do a report to the court, and the court may set a hearing if there's something of concern. So do understand that once you're appointed indefinitely, and the court is going to continue to monitor it by having a court investigator come out to visit. Next slide. Once you've been appointed as a conservator, you need to understand the conservatee still has rights, okay? You have been assigned to help that person in certain areas of their life, but not necessarily to take over everything. So here's a series of slides that shows what kind of rights they retain unless the court has specifically taken those rights away. So let's look at the next slide. These are a list of some basic rights that your conservatee is always going to have. They will always have the right to be represented by a lawyer. to ask the judge maybe to replace you as a conservator, to ask the judge to end the conservatorship if for some reason they think they don't need it. They can make or change a will. They can directly receive or control a salary, and they can control their own allowance unless the court has basically taken that power away from them. Next slide. The conservatee also retains the right to vote unless the court has made a specific ruling at the hearing that they cannot appreciate the voting process. And so unless the court takes that right away, they still have the right to vote. And that's part of the petition you'll see if you ever do try to file that. That's one of the documents that will be addressed. They also have the right to see family and friends. This is a really important one. You cannot, as a conservator, isolate the person from their family or their friends. If they want to see them, they have the right to see them. And unless, if you have a concern that there's a particular person who might be endangering that person or a bad influence, unless you have a legal authority through maybe a restraining order to keep them away, they still have the right to see that person if they want to. So do understand they have the right to see whoever they want unless there's some sort of court order preventing that person from being around them. They also have the right to receive personal mail. So that's a basic right that stays with them even though they're conserved. Next slide. Another right is that unless the court has given that right away to you, maybe to manage, they still have the right to make their own medical decisions. But again, if in the conservatorship process, the court has given you the exclusive authority, then basically you're the one who's going to be making those decisions for them. Unless the court has taken that right away, they still have the right to marry or into a domestic partnership. And, you know, same for any type of transactions or necessaries of life, they have the right to engage in those activities unless the court has deemed those types of activities something that they cannot do and maybe give to you as a conservator. Next slide. And finally, they have basically the right to engage in any activity they want to, unless the court has specifically taken that power away from them. So understand that the conservatorship is only to help the person in certain ways. The court does not want to take a whole lot of powers and legal authority away from them and give to you to maybe manage. So it's going to be a constant assessment, whether things change or whether things have to stay the same. Okay, so that's pretty much it for the presentation. And I guess we can have some questions. Anyone? Here's my contact information.
Thank you, Katherine. Yes, I have questions here for you. I'm looking in the chat box here. And can you still hear me?
Yes.
Oh, okay. Let's see. Okay, our first question. Okay, our first question is, do you need an advanced health care directive if you already have conservatorship?
Well, it depends on what kind of powers you've been given, but no, not necessarily. If you've been given the power to make those medical decisions for them, you don't need an advanced healthcare directive. And basically, you could not get one because if you remember in the beginning, an advanced healthcare directive has to be signed by the disabled person, and they have to be of sound mind to know what they're doing. So the very fact that you're conserving them basically says that they don't have the capacity to sign an advanced healthcare directive. Now, if you had one done before they were conserved, it's likely the court will have just made a determination of what kind of authority you need as far as medical care. So it's probably not going to be of use, basically, if you're conserving them. But remember, the advanced healthcare directive initially is an alternative to conservatorship. And the only way that's going to be effective if the person understands that they have the right to make their own healthcare decisions and they're turning it over to you to manage. Okay, so hopefully that answers the question.
Okay, thank you. The next question is from Kimberly. Is it important to have a trust set up along with the conservatorship?
I'm presuming if you're talking about a limited conservatorship, I don't know, but well, even with a general conservatorship, I think it's a good thing to do because if the person does have assets, You know, you want to make sure, especially with a special needs trust, what I discussed, that they're going to be cared for, and if they have assets. But that's only comes into play if they have assets that need to be managed. But you know, if they don't have a lot of assets, if they only have SSI, um, you know, I'm not sure you're going to really need a trust. It's usually a trust with a special needs trust is to supplement their government benefits that they're getting in, like SSI or Medi-Cal.
Okay, next question. Does someone have a place to recommend for help with the application for this process?
Okay, that's a good lead in. All right. So there are many law firms, you know, my particular law firm does conservatorships, but you can also, I said in the beginning, there's a legal aid organization that is called Bethesda Legal Services. They have a clinic, a self-help clinic that will help you prepare the petition documents for free. That is only though if you're willing to represent yourself. So do understand that. They are. I used to be with Bethesda, so I understand that they are very, very busy. Now with the coronavirus situation, I think they're only offering telephonic assistance. I'm not quite sure, but you know, you can try them, but do understand if you go through the Bethesda clinic, you will be responsible for representing yourself. They will not act as your attorney. They'll basically help you prepare the documents. Otherwise, you know, you can go to a law firm. My particular law firm is in the South Bay. We do conservatorships, but you can look up maybe bar associations of the State Bar of California. Another good organization to contact is CANHR, C-A-N-H-R, if it's a situation where, you know, it stands for California Association of Nursing Home Reform, but they have an attorney referral service, and they have a lot of attorneys in their referral list that do conservatorships too. So Bethesda Legal Services, if you want to represent yourself, but understand they are very busy because, you know, they're free. So a lot of people want to use their services. You can call your local bar associations. You can call the State Bar of California. You can call me. So a lot of opportunities. But again, it's whether you are able to, you know, spend money as far as an attorney representation, or you want to try it yourself, you can do that.
And we can have Christine put in the chat, because we have so many other questions that I need to ask to Katherine. But if maybe Christine could put in Bethesda, and some of the places will be in the chat box, and then you can pick up some of that information. So the next question was from Lisa. If you petition court to make medical decisions, is this like a medical conservatorship or a medical conservatorship?
Not sure I quite understand the question, but maybe I'll approach it this way. If you're asking to be able to step in and make decisions for the person, maybe, you know, what kind of medications they get, what kind of treatment, if they need surgery, that's what you're petitioning for. Medi-Cal is the California version of Medicaid. It's needs-based, and it's basically to entitle you to get some support for payment for medical treatment. So they're kind of two different things. But you know, what you're doing when you file for a conservatorship to try to help the person with their medical care, you're going to have to specifically ask for that authority in your petition and say, you know, my person is unable or they lack capacity to make their own medical decisions, so I need to step in and help them. Okay, so that Medi-Cal is kind of a different thing. So
yeah, it may have been actually medical conservatorship, but you know, in our world, sometimes we pick up the Medi-Cal piece.
Oh, I see. Okay. Okay.
So
but
the next,
you would be fine for over the person.
Okay.
Okay.
The next question, I'd like to put my eldest son as my co-conservator instead of my husband. Do I need to go through the same application? Where do I start?
Okay. Yes, you do. So what happens is when you prepare the petition, you would be the petitioner, and in the petition document, it says, I, the petitioner, nominate A, B, and C, or myself and my son to be conservators of whoever you're trying to apply for. So it's just a matter of who you're going to designate in your petition. the law does not have any specific preference depending on your relationship with the disabled person, whether you're going to be appointed or not. But it does have a list of suggested individuals who could be a conservator. So it could be a parent, a spouse, a child, a friend, even if there's nobody else, the public guardian. And there's no hierarchy. I mean, you could have a lousy spouse and a great child, you know, who would take that responsibility. You know, as far as lousy, I only mean that they wouldn't be very good at providing the care for the disabled person. So you have the right to name who you want and nominate who you want to serve as a co-conservator with you. So just because you know, your spouse happens to be the biological father does not necessarily mean you have to nominate them. All right. So you can nominate whoever you want, basically. It's just, I would suggest do what's practical, who's truly involved in the care of the disabled person. You don't want to name a whole bunch of, you know, 10 different people because you think if I die, everything will be okay. It doesn't work that way to begin with, because you're going to have to go in and amend letters. And secondly, you know, do what's practical. If you name 10 people and your son or daughter needs emergency surgery, you're going to have to get agreement with 10 people. Remember, they have equal say in the care of the disabled person. So do what's practical, do who's involved in the care of that person, and understand the investigator is going to check out and find out if this person appropriate, how involved they've been too. So you want to choose carefully, because you're going to be working with them and making joint decisions, and you're going to have equal say. Okay.
Thank you. Next question is from Melinda. If I do not have conservatorship in place yet, but have 7 POA, powers of attorney, will I be able to fill out her SSI application on her behalf?
I'm not, can you repeat that question again? She has 7.
If I do not have conservatorship in place yet, but I have 7 of the POA, will I be able to fill out her SSI application on her behalf?
You know what, that might be something that you would have to check with SSI, but SSI is federal, so they don't even always recognize the state conservatorship. So it probably depends on what powers you were given in your power of attorney to act on behalf of this person. And I do know from some of the cases experience that the Social Security Administration office is pretty pretty strict on getting certain requirements. You know, I have one case where even though the person's conserved, they say, we're not going to recognize the conservatorship. We want a letter from the doctor to say that this person's disabled, because it's federal and they don't really recognize the state conservatorship process. So, you know, it varies from office to office, but I think that question I might have to probably maybe talk to you some more about what specific power of attorney terms you're talking about to give you a clear answer on that. So, you know, Teresa can give you my email and I'd be happy to talk to you specifically.
And we're going to have your email in the chat box as well.
Okay.
So if they would like to email you after the meeting, they can.
Okay, yeah, I probably need a little bit more clarification.
Right. So
Happy
I have
to do so.
Another question. I don't believe we need a conservatorship, but how can we get assistance in determining which alternative works best for our consumer and what process to follow to accomplish this alternative?
Okay, I think the first step, maybe if you're kind of bordering on, I don't know if this person does or does not know what's going on, to get the capacity declaration done, you can Google it. It's called GC 335, and if it's a dementia case, that 4th page is 335A GC, or just Google capacity declaration California. That's a good way to start. That if you're not quite sure whether this person truly needs help, if you get a doctor's assessment through that capacity declaration, that will help you understand whether they have, you know, enough mental ability to make their own medical decisions and that kind of thing. So I would start with a capacity declaration. Go to the doctor.
Okay, next question is from Olivia. The IRC record it's a question. Is the IRC record a legal requirement?
The regional center record, IRC.
The IRC record, is it a legal requirement?
If you're talking about the regional center report, It is a document that's a report that's recognized by the court, and it's part of Los Angeles County's filing. They need to, if you're filing for a limited conservatorship for somebody who's developmentally disabled. The regional center obviously is not going to weigh in on a general conservatorship, but it is an important document that they will not grant a conservatorship often in a limited conservatorship unless they have a regional center report, if that's what you're referring to when you say the IRC.
Catherine,
And
what if
Olivia,
you're
you,
not part of regional center?
Okay, if you're not part of regional center and you still have somebody who's developmentally disabled, okay, this is a kind of a touchy thing. If you're able, there are some cases where maybe you have somebody who used to go to the regional center, and for whatever, I have this happen oftentimes, they quit going for whatever reason, and they want to file for a limited conservatorship because they want to ask for their 7 powers. I would always recommend go back to that regional center and get an assessment so you can ask for the specific 7 powers. Now, in some situations, maybe the person has gone to the regional center and they've rejected services. If that's the case, understand the regional center also has a appellate unit that you can go and try. I guess it's called appellate unit, but it's basically a department where you can ask them to reconsider. So that's one option, to say, hey, you know, this person did have this disability before the age of 18. There are some cases where, you know, I know there are some people, maybe they're in their 80s, they're taking care of their son or daughter who's 60, who's been developmentally disabled their whole life. They've been caring for them, and all of a sudden they've run into roadblocks, and somebody tells them, go get a conservatorship. So they have no medical records to support that this disability manifested before the age of 18, and they run into problems with the regional center saying, you've got to prove to us that this manifested before the age of 18, otherwise we can't give you services. If that happens and you can't get the regional center to reconsider, then your other option is to file general conservatorship. You won't be able to ask for those specific powers laid out by a limited conservatorship, but you know, maybe you don't need them. It kind of depends on your case, but you can always file a general conservatorship, but instead of a limited conservatorship, if you don't have a regional center connection, and the court is just going to have to specifically tailor its order and what powers they're going to give you, because again, it's general. It's not automatic. I ask for all 7 powers, you know, like a limited conservatorship.
okay, next question. I know we have to be mindful of your time, so I want to get through as many as I can. Does a co-conservator have to sign off on every document or attend every meeting or appointment?
It kind of depends on the situation, okay? If I have a situation where we just got a daughter and a mother appointed as co-conservators, and they've gone to the bank and they're managing the estate, so they have to open what's called a conservatorship account, and the bank is saying, no, you have to come back with a court order that says you can sign independently. We don't want to, you know, say that both people have to sign off. So it kind of just depends on the situation and how difficult the particular entity is going to be. Some banks are going to require a specific order that allows one co-conservator to sign independently of the other. Other places, hospitals, may say, no, we want both. And a lot of it is their risk management. People tell them one way or the other. So it kind of depends on the facts.
Okay, thank you. The next question, if I were to pass, can I list my sister as sort of a beneficiary to take over as the conservator?
Okay, so if I'm assuming you're saying if I am appointed as conservator, but I want my sister to take over in case I'm not around. Okay, so if that's the case, you could do 2 things. You could file a petition and have your sister be a co-conservator, and then that way, if you pass away, she's already knows that this exists, and then she can go in and amend your letters of conservatorship so her name is only on the letters as opposed to both of you. That's one way to do it. You could do a trust, write your own trust if you have assets, and say, and you know, I have this son who needs help, and so I'm the conservator now, and I would nominate my sister to be the conservator in the event I pass away. It's not required. Your sister could agree or refuse, but that's one way to do it. But it's important to think ahead and plan ahead. And so one easiest way is to just at least notify the person, look, all right, you don't want to be a co-conservator now, but understand this is a situation and somebody's going to have to step in if I pass away. Because you don't have to name her as a co-conservator. You could just be in communication with her. I'm assuming she's involved with your son or daughter, whoever you're trying to help. And so they just have to be alerted that, hey, somebody's going to have to immediately step in. If you don't name her in your petition and you're only appointed, but she knows that this is a situation, you pass away, she can come in and file her own petition as what they call a successor conservator, meaning there's a vacancy now because the appointed conservator has passed away, and I am petitioning now to step into their place. So, you know, I had a situation just now where just recently a case where the parents were appointed for many years, and they both passed away. So the daughter was never named in the letters of conservatorship or the petition, but now she is filed to be appointed as a successor conservator. She had to do it on an emergency basis though, because they weren't expecting the father to pass away. The last, you know, he was the last conservator. So, you know, you want to just plan ahead if that's the case, if you're going to be the only appointed conservator.
Okay, I'm going to jump around because I see several people are asking, there's two questions that are being asked quite a few times. One, what are the fees for services such as, so let me just start off with this one, actually. What are the fees? Will they be waived for someone on Medi-Cal or on the institutional deeming waiver?
Okay, this is a good question. Okay, so when you file for conservatorship, it can be expensive. In Los Angeles County, it's $1,115. So everyone hold your breath, don't worry. If you are filing on behalf of a conservatee who has SSI or Medi-Cal or other public benefits, you can file a form called a fee waiver. Okay, it's based on the income of the disabled person, not necessarily you who are petitioning. So if your person has public benefits, it's an automatic qualifier for you to be excused from paying that expensive filing fee. If indeed they don't have that, there's another place in the fee waiver form that says, you know, they don't have public benefits, but I still need help because it's a hardship. And then you explain why it's a hardship by attaching another form that shows these are all my household expenses. This is everybody lives in the house. This is what their income is. This is what our expenses are. You know, it's just creating a hardship. Please, you know, grant me an excuse to pay the fee. So that's done on a, you know, case by case basis with the court, but that's an option too in the fee waiver to maybe get, you know, the court to consider it's on hardship. You know, there are ways to try to be excused from paying the filing fee. If you don't have a fee waiver, understand you may get hit with the investigator's fees as the conservatorship continues. If the person you're disabled has an estate, you could get hit with paying the court-appointed counsel's fees. Otherwise, the county pays for the court-appointed counsel's fees and the investigator if you have a, you know, fee waiver. So there are ways to try to get around it, but you know, it can be expensive.
Okay, so we have maybe, I'm just looking because this one here also, about 3 people are asking. If you move out of the state, do you refile in the new state? And the other one said, what happens to the conservatorship if the conservatee moves out of state?
Okay, good question. Yes, unfortunately, conservatorship law is not uniform, as I said, from county to county and from state to state. They're working on it. There, you know, there's a law that some states are weighing in. It's a uniform code that they basically, some states have an agreement that if you're conserved in one state, they will recognize it, but there is paperwork that needs to be filed. So if you file for conservatorship, you're appointed here in Los Angeles County, you want to move out of state, you're going to have to petition the court in advance to say, I am intending on moving the conservatee out. And the court is going to have set a hearing and they're going to ask, well, we've already established this person needs a conservatorship. What are you doing in this other state? And you're going to have to check with the other state what their requirements are as well. Okay, so it is a little bit complicated, and I would really suggest that you go through an attorney to try to do this because it varies from state to state. And sometimes you have to go to the state you've moved to get an order that says we will recognize California's conservatorship. and then you bring that order back to California, and then you file a petition in California. So there's some complicated rules that you need to follow if you're moving. If the conservatee moves out of state, hopefully you've notified the court in advance. If you don't and they just move, that could be problematic because the investigator is going to check, the court's going to check, and they're going to say, well, what happened to this conservatee? And the court may order you in to explain. So you want to notify the court what's going on because they're monitoring it once you've been appointed.
Thanks. A few more. Can we begin this process before a child is 18? The child is a 17-year-old now. Some providers won't take the case until they are 18 and a half.
Okay, so I'm not sure about that second part, that some won't take it when they're 18 and a half, but what we usually recommend, I usually tell people to start the process maybe about 6 months before the 18th birthday, because a court is just going to set a hearing when they set it. And as you can see, you have to file a whole lot of documents. You have to get in line and get a hearing date. So usually around 6 months before the 18th birthday is a good time to file. You can always file after they're 18. I mean, there's no limit to that. But if you want to time it close to the 18th birthday, that's usually a good time to do it. Oftentimes, if the court sets a hearing and the person is not yet 18, they're going to say in the order, this does not take effect until the person is 18. Because again, conservatorship has to do with an adult. So that's why you got to try to time it right. Understand the court's going to set the hearing when they set it. So it's kind of up to you to sort of try to time it right. Sort of tailing on that last topic of SSI, this is kind of not part of the question, but one thing to think about too is with the fee waiver cost, you might try to get SSI in place before the 18th birthday. They don't always do it. Sometimes they say, we're not going to put you on SSI until they're actually 18, but that's one to dovetail into getting a fee waiver too when you file. You want to kind of get close to the 18th birthday, maybe try to get your person on SSI. And then when you file, you'll be able to save some money if you get that fee waiver that says they're automatically qualifying for SSI. And so you're excused from the fee waiver. But usually try around 6 months before the 18th birthday, because they're still a minor if they're 17. By the time you get a hearing, if they're still 17, it's not going to take effect until they're 18.
Well, I think this is the last, this is the last one. Where did it go? 1 second. Oh, need more explanation of the sound mind part. What does the disabled person need to have?
Okay, well, a capacity declaration can take care of that, but sound mind is basically they understand that they have a right to, say, for example, make their own healthcare decisions, and they understand that maybe they're having difficulty doing it, and so they're going to turn over that right to some other person. Okay, there have been situations where somebody who has autism, but they're high functioning enough to understand, I want my parents to make decisions for me, that they can sign a power of attorney. You don't need a conservatorship, but really it depends on whether the person really understands it's their right to make their own decisions, but they need help, and so they're going to turn over that right to maybe the parent or the son or the daughter. I mean, we have cases like that with dementia. Maybe somebody's starting to have memory problems, they're starting to forget things, but they realize they are, and they realize they need help. So they agree to have a power of attorney or advanced healthcare directive done because they understand they seem to be having more difficulty that's progressing. Sound mind really is also a subject of a different type of conservatorship of which I won't get into because we're only talking about probate conservatorships, but it has also a legal definition as well. And basically it's if the person, I'm not sure if I want to even get into this to confuse you anymore, but if you're talking about somebody who is out homeless and they can't, take care of themselves, but they know enough to go into a dumpster to get food because they know they need to provide for their own food and shelter, they might be deemed not gravely disabled enough to understand that. So it's kind of amorphous phrase that's used, but sound mind basically for purposes of this presentation is whether they understand they have a legal right and they're going to give it over to somebody else.
Thank you, Catherine, so much. And I'm going to pass it over to Christine to sign you out.
Okay.
But thank you. Thanks, Catherine.
Uh-huh.
Yeah,
Thanks.
thank you. Thank you, everybody. Great questions.
Yes.
I've typed in the chat all the contact information, either that Catherine mentioned, Catherine's, and also Teresa and myself. If you look in your email, we'll try to get a copy of this out to you so you can, have a copy of the slides, but we'll also post it on our YouTube channel for Family Focus. So you can watch it again if you need to go back over it. So I'll post that link for the YouTube channel right now. And otherwise, thank you, Catherine, so much. We miss you in Antelope Valley for sure.
Hope we can do this in person soon.
Yay.
Thank you, everyone. And continue to check out our website as we will be offering more webinars and our social groups that we have as well. So we are family focused because of you. So thank you so much.
Thanks, everybody. Stay safe.
Bye.
Bye.
I need my glasses on.